joining us today. We're live from Houston, Texas. My name is Emily Newman. I'm an immigration attorney with Reddy & Newman PC. We're here today to talk specifically about the hot topic of STEM OPT extensions and working at third-party sites. We know that immigration is a very complex topic, so our goal is to make it simple and provide you with the clear guidance you need in order to take action in your case. Today I have with me my partner, Rahul Reddy.
Hi, this is Rahul Reddy. I'm a partner in Reddy & Newman PC. We established our firm in 1997, April 1st. And today we are here to discuss the STEM OPT extensions, which are given to the people who have STEM degrees. And after their 1 year initial period of OPT, they are allowed to have a 2 years extension if they have a STEM degree and if their company which is employing has is an E-verified company. Now, today we are going to address only related to those people who are working at third-party site. Those STEM extension in that 24-month period who are working at the third-party site, because the USCIS, early part of the 2018, they updated their website indicating that it is not appropriate for the students who are on the 24 months OPT to work at third-party site. Now, Emily, the Department of Homeland Security on its website, which is different than that of the USCIS website, in October of 2016, they clearly mentioned that the STEM extension people could work at the off-site location, not in the company's working, but at an off-site location. That was in 2016. Whom do we believe here? Is it 2016, the Department of Homeland Security, through ICE, clearly pointing out that the employees on the STEM extension can work at third-party site, or the USCIS that says that no, you cannot work at the third-party site? Then again, at the bottom of there, they linked it back to the Department of Homeland Security. Whom to believe? Or is it Department of Homeland Security or USCIS?
Right, yeah, I think obviously it's a huge conflict between the two agencies. The one important thing to remember is the STEM extension for the 24-month with the training plan requirement was created by a regulation that was published by ICE. ICE is the agency within the Homeland Security that's responsible for all things related to student visas. So ICE is actually the agency that issued the regulation, yet USCIS is the one giving us this differing interpretation. So the question is, which one do you believe? Nobody knows, because there has been no further guidance, nothing coming from ICE saying USCIS is right, nothing further coming from USCIS saying this is the new policy from this date going forward. It was just a website update that happened quietly with no announcement. It's not a policy memo. So the question is, which one do you go by?
Now, Emily, coming to the point now, we're pointing out two websites. Does the government websites determine what the law is? Or is it the parliament that describes, the Congress which describes what the law is? Or is it the regulatory authority that would describe what the law is? Or is it just a website which decides? Now, can you explain what does the law says, what does the regulation says, and how is it differing from the websites of the Department of Homeland Security and that of the USCIS?
Right, so for employment authorization of F1 students, Congress really gave that to Homeland Security in order to interpret and promulgate regulations for who can be authorized to work while you're on F1. So we do have the regulation from Homeland Security through ICE that created this STEM extension and gives us all the guidelines on how we're supposed to process the STEM extension. So the regulations should be the starting point for any kind of inquiry. From that, from time to time, we might see guidance interpreting those regulations. So Homeland Security through ICE has given us guidance in the past in October 2016. Now USCIS is giving us guidance. The interpretive guidance should always be in line with the regulation. It can't conflict with the regulation, But here, what's interesting is the regulation never mentions third-party placement at all. The regulation itself does not mention staffing agencies or temp agencies or off-site employment or on-site employment.
Does it mean that the regulations prohibit the third-party placement for the consulting companies?
No, according to the regulation, the requirement is that there must be a bona fide employer-employee relationship. Now, is bona fide employer-employee relationship defined anywhere in the regulations? No. The only definition that we have of it really comes from H-1B policy memorandum from back in 2008 for H-1B's determination of employer-employee relationship and whether it's bona fide. Now, it wouldn't make sense to me that USCIS would have one definition for H-1Bs and a different definition for F-1s.
For the same bona fide employment.
Exactly. But that's exactly what they've done. They have restricted consulting companies from F1, whereas they allow it for H1 under the guise that the training has to be closely supervised and you really, according to them, can't do that remotely or from off-site.
Now, Emily, you're telling that in the regulations it doesn't define the third-party placement is allowed or not allowed. So in that case, does it mean that the USCIS can unilaterally say that it's not allowed, even though the regulations are silent? Or should they go with the bona fide employment definition, what they have given in 2008? The employer-employee relationship has been kind of controversial with the USCIS. The IRS defines employer-employee relationship differently. The USCIS defines it differently, and we have been living with the USCIS definition all along. Now, the USCIS is saying a different interpretation for the bona fide employment. By the way, STEM extension is not USCIS. It should be the Immigration and Customs Enforcement. Why is USCIS defining, and why is USCIS defining contrary to the ICE, which has authority over the student STEM extension people? Now, in light of these things, that the ICE and USCIS are differing in their interpretations, when we are applying for the immigration benefits like the H-1B or some other transferring it to another visa, who is going to be the controlling authority, and how do you expect them to rule?
Right. I think that's the reason why USCIS has put out their interpretation, because USCIS is actually the one that's adjudicating these benefit applications. So the I-765 application for the STEM OPT extension, as well as the I-129 application for a change of status to H-1B, those are all adjudicated by USCIS, not ICE. So in my opinion, I think that the USCIS definition is more likely to be the one controlling, because it's USCIS adjudicators that are looking at that case. I think it's going to be very difficult for an adjudicator to say, well, I know our website says this, but I'm going to go ahead and approve this application, even though it's not in compliance with what's on our website.
Ooh, that doesn't look good, Emily, because if most of the rulings will be done not by the ICE, but it's going to be done by USCIS, we're going to see a lot of problems for the students. Now, with ICE, with USCIS, now as a lawyer, as an immigration lawyer, can an individual work at a third-party site on a STEM extension? Can you give a simple yes or no answer?
No, because I'm a lawyer. We're not allowed to give simple answers. But I think that the safest thing to do to protect your status is to not work at a third-party site if you are currently on the STEM OPT extension.
But if they don't work on this, if they don't work, they're violating the STEM extension status by itself too.
Right. You can't just not work. You can't be unemployed and cross that limit of the number of days of unemployment. So you either need to start looking for a different job that works in-house, or work with your employer to move your job to their in-house location rather than working at the client site.
Now, in the scenario where a lot of people have filed the H-1Bs at this point of time, Emily, now we are getting the request for further evidence, for specifically pointing out to the USCIS website, what should they do when you get an RFE that is asking for the status maintenance if the person has worked at a third-party site. What should the strategy should be for these students?
Yeah, these RFEs, they specifically say, this is what our website says. Here, there's no evidence that your employer is providing the appropriate training because you're working at a third-party site, but here's the evidence you can submit. So they give you the option to explain why the student is working at a third-party site, to explain how the actual employer of the student is providing the appropriate STEM training. They want the name and contact information for the employer, the STEM OPT's actual employer's personnel who's doing the supervising. They want a copy of the 983 form, and then they want evidence of the STEM training plan to show that you've complied with what's on the I-983 form. Now, even if you provide all of those requested documents, in my mind, you're creating the trap to hang yourself, basically, because the USCIS is coming out saying, we don't think that this is proper. Now you're providing them with all of the evidence showing that it's not proper. I think most in this situation...
So what's the other alternative?
Right, you're going to end up with a denial of the change of status. Now, one option would be to, in response to your request for evidence, request that the case be converted from change of status to consular processing. When you file a consular processing H-1B, there's no requirement to submit maintenance of status documentation. Therefore, the issue of the student maintenance of status should now become irrelevant because you're requesting consular processing. The H-1B petition itself should still be approved as long as all other requirements are met. Now, that does mean that once you have that approval, at some point you're going to need to exit the country, apply for a new visa stamp for the H-1 visa, and then come back to get into H-1B status.
Now, Emily, you're telling that consular processing, they're not going to rule on the STEM extension part of it. But the other issue is that what about for those people who are in the cap gap? Now, do you still suggest for them to do the consular processing? Because if they're in the cap gap, if you request a consular processing, you are not allowed to work on the cap gap because cap gap is only available if you apply for change of status. It's not available for those people who are on the who applied for the consular processing. You know, our audiences already know that what a cap gap is, that if their STEM extension is expiring between April and October of 2018, if they file the H-1B for change of status and their H-1B gets selected, they have the employment authorization until October 1st. In that situation, what do you suggest?
Yeah, I still think that consular processing is a good option. Now, the important thing to be aware of, like you mentioned, is generally cap gap is not allowed in a consular processing H-1B request. That means, and there's no guidance on this from USCIS, but what I would recommend to my clients who are in the cap gap, who are choosing to consular process now in response to a request for evidence, is to stop working as soon as the request for evidence response is received by USCIS. Assume at that point you're no longer eligible for cap gap. Plan to exit the country as soon as possible. Wait for the H-1B approval outside the U.S. Once it's approved, go for stamping. Come back on or after October 1st.
Emily, you're telling that the USCIS has quietly updated the website and now they have issued the RFE, which you read a part of those RFEs, indicating that they probably are inclined to deny the change of status application. However, the DSOs have authorized the 983 applications based on which the I-20 was been endorsed, through which they filed the 765 with the USCIS, which is the Immigration Service. And they approved the 24-month extension based on the 983 that's saying that they are working at third-party location. Now you're telling that they are going to deny it, the same thing what they approved it before?
Right. Yeah, I mean, that's the difficulty with this website change. There's no date that it becomes effective. There was no advance notice letting people know that from this date going forward, we're no longer going to allow this. It was just, this is the new rule, everybody should comply. No guidance on what to do if you previously worked at a third-party site. Just no guidance at all, other than you're not allowed to do this anymore. So I do think it is quite unfair that students are being put in this situation through no fault of their own. There was no guidance before, and now all of a sudden you're saying something that I've received DSO approval, I've received USCIS approval for, now all of a sudden I'm potentially out of status and unlawfully present if USCIS denies my change of status.
Now, Emily, you put out the RFE. I mean, you've been reading in the RFE, and we have received a lot of RFEs on the STEM extension. Of course, we have responded to a lot of RFEs. Did you got any results for the change of status denial as of yet?
No, we haven't. So
have you got approvals for it when you responded?
We haven't received any results yet. So everything we've responded to within the last 60 days. Processing time for these RFE responses is normally at least 60 days, so we just don't have any results yet.
We will update you if there is any results that are going to pop up with regards to the STEM extension on our everyday Tuesday 5 o'clock presentation. Now, having said this, Emily, even today, have you noticed any 765 denials, which is the employment authorization document they filed for the STEM extension, based on the third party working through the endorsement of the 983 and the I-20?
Not that I'm aware of. For those that have filed the I-765 for the STEM extension, I'm not aware of any denials, but I also don't know how many would have filed in between January and now, because if you're filing your STEM extension now, that means maybe you would have graduated in May of 2017.
Right.
So people probably are going to be starting to file their extensions now, or have filed, and maybe we'll start seeing those denials. But as of this moment, I'm not aware of any.
Okay. And Emily, are the DSOs still endorsing the 983s where their the students are working at third-party locations?
As far as I'm aware, some of them are, and a lot of them aren't. So it really it's up to your DSO in the school at this point, which again is very unclear guidance out there of what these DSOs should be doing, and that could ultimately put your status in jeopardy, unfortunately.
One question that is popping up, Emily, is that I am working on the STEM OPT extension at a third-party site, as there's a lot of debate going on with regards to whether or not the person can work at the third-party site. The question here is that, can I just go join a university and get a day one CPT and start working, because you never said that there is a restriction on third-party placement on the day one CPT. Is that a good idea?
Well, that's true that there's no restriction on third-party placement for CPT. That being said, if you're going from STEM OPT at a third-party site to a day one CPT at the same degree level, I think you are jumping from being in the frying pan into the fire.
Oops.
You're just digging the hole deeper. I would not recommend that to anyone at this point, based on the scrutiny of these CPT programs, the problem with CPT at the same degree level. We're also seeing requests for evidence on that issue with H-1Bs that were filed this year. So I think that's just really making it worse.
If we were to choose a consulate, which consulate we should be using? This is a question from Mr. Mohammed. The consulate you should be choosing should be your home consulate. Don't try to choose the consulate of Canada or Mexico. We do not advise that, especially under the circumstances. We would recommend to go to the home consulate. Whenever you're when you have any doubt, you should always try to go for the home consulate.
So if someone is currently employed by a consulting firm and they're placed at a client site during their STEM OPT, if they now can work it out with their client site to become a direct employee of the client, update their 983 form, would that be allowed? Well, even though they're doing the exact same job?
In the STEM OPT, if they are at the same place, yeah, if they can join the end client. However, Emily, because of the way the USCIS is interpreting, it might not cure the previously working on the third-party location, because all this information is already fed in the CIVIS system that the person is working at third-party site. The address has been provided at third-party site, not at the employer location. So it may not be able to cure it. There are certain alternatives to curing, maybe traveling might cure it, but I would recommend the audiences to consult with their lawyers before they take any steps though. Because just by moving from a third-party site to an end client directly working for the end client by itself doesn't cure what was being done before. It doesn't cure.
So Sachin has a question. What exactly is training when we're talking about STEM optional practical training? Isn't the work the training?
No. The reason why you have been given the STEM extension is that you have been given, you came into this country on a student visa to obtain a degree, and then you got the degree, and the US wants you to be trained in the relevant matter and the work experience in United States. They want you to be trained on that particular subject for which you got the bachelor's or master's degree. And the training capability should be available with the employer so that the employer can train the employee on that particular field. To elaborate a little bit more, the company must have a proper planning to train the employee. The employee must be completely controlled by an employer. The employer must supervise the employee. Any other things that you want to elaborate on the training, Emily?
Yeah, I think that the person or the company that's signing the training plan is the one that has to be giving the training. And according to, now I will say on the ICE website, on the Study in the States website, they do specify for staffing companies and temp agencies that a staffing firm or temp agency cannot be the one to sign the 983. So you can use a temp agency or a staffing agency to find the employment, but the actual customer that you're placed at must be the E-Verify employer that is the one signing the training plan. Now, I think the difficulty with all of this is in all of the guidance we've received up until the USCIS website change, it only referred to temp agencies and staffing agencies. A consulting firm is a completely different type of business. So a temp agency, you know, the company is going to basically be a recruiter, and then they're going to place you, and they take care of the paycheck and the benefits, but they have no role in what you're doing at the customer location. The customer is in charge of everything. They're giving you your daily assignments, they're reviewing your progress. So that is why the temp agency situation won't work for a STEM OPT extension. Now, a consulting firm is a business that uses its expertise in a certain field, places people at the client site to use that expertise. There is no specific guidance talking about consulting firms specifically. It's only temp or staffing agencies, and then now we have the website that just says all offsite employment is not allowed. So that's where I think the difficulty is, because we really haven't had any guidance other than specifically referring to temp and staffing agencies, but consulting firms really aren't the same thing.
This presentation is exclusively for the third-party placement on the STEM extension. So try to restrict your questions only to the third-party placement. And if you have any other questions, you can come to our daily conference calls. You can come to our Tuesday live, which is in a general Facebook Live. This is specifically for the STEM extension. Now I want to point out a very good question that Vinay has pointed out. Beautiful question. I would call the question of a day. He filed the H-1B on the change of status, and he got an RFE. Can he now convert into consular processing?
Exactly. That is exactly what we're recommending to do. Now you still have to respond to the RFE, but the response is, I request to change my application from a change of status to consular processing. Please send notice of the approval to the consulate in whatever consulate you want to go to, and that's it. That is the RFE response.
He has also good other questions, is that does by that doing the consular processing immediately turns to unlawful presence? No. It doesn't. Just because the employer converts the consular processing, change of status to the consular processing does not turn you to unlawful presence. So the 60-day rule is not applicable for you. You're fine. You would be still considered to be in legal status once you apply for the consular processing.
Unless you're on the cap gap.
That's right. Unless you're on the cap gap. Now, then the 60-day rule is applicable if you're on the cap gap.
All right, Gaurav also has a really good question. What if I got an RFE and I'm on the STEM OPT, but my RFE is only on specialty occupation? They haven't raised any issue on status. Should he convert to consular processing, or should he continue with the change of status?
I would, at this point of time, will not try to convert that into consular processing unless the STEM extension has been raised there in the RFE. As we noticed, Emily, that there are a lot of RFEs that we have received. Some of them are not addressing the STEM OPT extension third-party placement. So if that is not addressed, I would not try to convert into consular processing. Now, two things that I want you guys to be very careful is that there is a chance that they might issue a second RFE. We have seen that previously in last year that they issue one RFE and they issue another RFE. There's a chance for that. Now, there's other thing that to be careful when they're going to issue the second RFE. I don't want you to cross the deadline of 180 days from the August 9th memo. That means from the August 9th, you may be determined, if by any chance USCIS determines you to be out of status, they're going to count the undocumented stay from August 9th if they consider that you have violated the status before August 9th. And the 180 days, why is it 180 days more important is that if you're unlawfully present in this country for more than 180 days, there is a 3-year bar. And the 180 days is hitting on February 5th. So the premium processing, we're expecting it to come in September, even though they did not address your issue of the STEM extension. I would not like this person to wait, get the things in premium processing approved, so that if anything happens, they can take corrective actions before February 5th of 2018. And one of the things, a lot of people ask this question, Emily, is that, oh, premium processing, doesn't premium processing get denials or RFEs automatically?
No, it does not. And I think that's a very common rumor that we hear, but it's really not the truth. If you're going to get a request for evidence, if you're going to get a denial, it's going to happen whether you file premium or regular processing. Just filing in premium is not what's going to cause an RFE or a denial. It's the petition filing that causes an RFE or denial, or the type of response to an RFE that causes it. So there's no reason not to upgrade to premium processing. It is not going to cause you to get an RFE. It's not going to cause you to get a more difficult RFE. They're the same as far as how they process the cases.
Garo has this follow-up question on, if the RFE did not address the STEM extension, can they still deny the change of status without issuing an RFE?
I guess potentially yes, but they normally don't. It's been our experience that when a denial happens, it's based on what the issues were in the RFE. If you respond to the RFE and then they find another issue, they won't do a straight denial on that other issue. They will normally send a second RFE, giving you a chance to respond to that one. Karthik also had a question. You know, if he's a student on the STEM OPT, he's already been working on a client site, but now he's working in-house and stopped working at the client site before August 9th. Does that cure anything? Does that make the August 9th memo go away?
No. Just because you moved to the in-house after August 9th, it doesn't cure what you have done previously. So however, as Emily was pointing out with regards to the August 9th memo, is that the effective date is February 5th. You might still want to get the result before February 5th if you are filing an H-1B, and then you can take a decision based on your lawyer's advice if you need to travel before February 4th outside this country. Devansh has this question. I filed the H-1B and now I haven't, and I'm on to be hired by contract to be hired to the end client. What do I do now?
He's already on H-1B?
Sorry, he's in STEM extension. He has a contract to hire to the end client.
So he's going to be joining the end client directly?
Yeah.
Well, I mean, you can do that. That's the whole purpose. The end client has to be the one to sign the 983 form, and you've got to work directly for them. They're the one that has to pay you. Now, if it's going to be through a different company, that as of now is not valid.
So as Emily pointed out before, is that, yeah, obviously, even though it might not cure what you have done before, but at least going forward, you will be in a better position if you would be working at the employer site. I mean, you can't go backward and undo the things what you have done, but going forward, at least you could, if possible, work at the employer location.
Salish has a question. He's currently on the initial 12-month OPT working at a client location, getting ready to file his STEM extension. What should he do?
He's working at third-party site?
Right.
Well, on the OPT, there is no restriction at this point of time that you cannot work at third-party site. But on the STEM extension, as we have covered before, the Department of Homeland Security is saying something, the Immigration Service is saying something. Obviously, the authority to rule is Immigration Service, so they may be poised to rule that you probably might have violated the status. So if you can get an end client directly and work for the end client, that's what we would suggest you. If not, if you don't have a job to work at the direct client, I would say that you will have to take your educated guess on what is best for you to do. We won't advise you anything, but you can take an educated guess on what you want to do. Emily, is there a litigation on this? Because we have heard a lot of things, rumors, that some IT companies have done some litigation. Can you educate on the STEM extension part if there is any litigation going on that?
Yeah, there was a lawsuit filed by a group of IT companies basically saying that this change to the website that was done without any kind of notice and comment, no regulatory action, is a violation of the Administrative Procedures Act, meaning that the agency did not follow the proper regulatory process in issuing this new guidance. That litigation is currently pending. I believe kind of the first round of responses is going to be coming next month at some point. Litigation generally can take a long time, so it's not something that we're going to see instant results on. If the court sides with the IT companies and decides that this website update was not a proper action, they could strike it down. We don't know what the outcome will be, and again, we don't know when it will happen. There should be some preliminary actions happening on that litigation sometime next month.
Pranava has this question. His OPT is completed. His STEM extension is getting completed on December 19, 2018. If his H-1B is not approved by that time, should he stop working? December 18, 2018 is not even cap.
Right, yeah. Once your OPT expires, you have to stop working. You would then move into the 60-day grace period. If your H-1B is still not approved by the time you are getting to the end of your 60-day grace period, you should consider exiting the country or re-enrolling.
Why is this guy not filing premium processing?
Yeah, for sure.
I mean, you could avoid that. We don't see a reason why you can't file a premium processing, get that thing resolved, because you have to stop working. It's not a good choice at all. Emily, on these STEM OPT extension people who are filing the H-1Bs with a cap, after September 30th, what do they need to do?
So if you're on the cap gap now and your H-1B is still pending from October 1st, you do have to stop working. The cap gap authorization ends September 30th. You will then be in your 60-day grace period. At the end of the 60-day grace period, you either need to depart the country or continue to maintain your F1 status by enrolling in a new program.
I'm on the STEM extension. I got an RFE right now, but my project is over. What do I do now?
Well, I think that's not quite in the topic that we're doing right now, but I think that there's a very good likelihood the H-1B will need to be withdrawn because the position no longer exists, but that's definitely something you should speak with your attorney about.
Emily, for some of the people who have not received RFEs on the STEM extension OPT, isn't there a new memo that says that they're not going to get an RFE, they're going to get a direct denial? Is that applicable to these people?
Yeah, so no, it's not. This new memo from September 11th only refers to filings that happen after September 11th. So you filed your case on April 12th, the memo does not apply to you. Even if you upgrade after September 11th, that is not considered a new filing. So you should still receive a request for evidence if one is necessary after September 11th.
Praj has this question: after responding to the RFE on specialty occupation with no STEM extension, can he still convert into premium consular processing?
Yeah, you can convert at any time, whether it's in response to a request for evidence or even after that.
But I would generally recommend Praj not to convert into consular processing unless the STEM extension is been addressed, though, because I don't want to poke the problem which doesn't exist, though. Mm-hmm. Now, I'm on STEM extension OPT extension, and I got my H-1B approved without any RFE, though I'm working at third-party location. Am I safe right now, or is there any steps that I need to take?
So just because you received the change of status, again, it does not make the prior violation go away.
So how do we resolve it, Emily?
The only real way to resolve it would be at some point to exit the country and apply for your H-1B visa stamp and come back into the country. Once you are finally able to file your 485 for your green card process, they're supposed to be looking at your status from the date of your last entry going forward. So they should not look backwards to your prior stay on F1 to determine whether there was a status violation, because you've since traveled, gotten the visa, and come back in. So again, with any kind of travel, before you make any plans, you should talk to your attorney and get specific guidance for your case, because a lot of times on this, on our Q&A, we say never go for stamping, don't go for stamping, don't go to the consulate. But this may be a situation where it's in your best interest to go to the consulate and get the visa stamped in order to clear up any prior violations.
Piyush has this tough question, Emily, that he's working at the third-party site location. He's expecting to file the H-1B in 2019 April. What do you advise him?
As of today, my advice would generally be file that H-1B petition in consular processing. Don't even request the change of status. Now,
going
of course,
in April,
yeah, we don't have any results on our existing cases to say, yes, we know this works or we know this doesn't work. So stay tuned for how things are being processed this year throughout the rest of the year. But based on where we are today, I think I would be filing that not as a change of status.
This person has a girlfriend who he intends to get married, a U.S. citizen. This STEM OPT working at third-party location, will it cause any problem for him in getting the green card through the U.S. citizen?
Again, it could, because the work at the third-party site could be considered a violation of F1 status. And any kind of violation that occurs can make you inadmissible, meaning you're not eligible to adjust your status. Now, there are certain exceptions to that rule. There is an exception under the family-based regulations.
Yeah.
There's an exception
because
under
of the immediate
employment-based.
relative-based exception. If a person is out of status, they could still get the green card without any problem. However, if you travel outside the country, though, then the 180 days or 360-day rule might kick in. When the USCIS determines, so you might want to consult a lawyer about your travel plans before you do anything. I would recommend that you consult a lawyer, though. There are exceptions available for immediate relatives, only for immediate relatives. That means spouse of U.S. citizens, parents of U.S. citizens, and children under 21 of U.S. citizens. There are exceptions available, but I would recommend that you contact a lawyer there.
Mahesh has a great question. We're telling people switch to consular processing. Is it really true that USCIS is just going to overlook the STEM OPT issues that they raised in the RFE and just approve the case?
Good question, Mahesh. Historically, we have done this many times, not right now, that it's been whenever there is a status issue. In fact, a lot of times the USCIS by themselves offer us, hey, your guy doesn't look to be in status. Do you want the consular processing though? So historically, we have done it many times, and the USCIS by itself has offered those things to us, and we have accepted sometimes, and sometimes we challenge the USCIS. So then what happens is that when we requested the consular processing, they never questioned the status though. Now, in scenarios where we challenged the USCIS saying that no, our client is in legal status, even in those scenarios, they have denied the change of status, but they still approved the H-1B. In almost every case where the H-1B is approvable, they approved it, but because the person violated the status, they denied the change of status. However, in light of the August 9th memo, in light of how this administration is behaving, it might not be good for you to get a decision from the USCIS indicating that you are out of status, thus by we are issuing a H-1B without I-94, for which you have to go to your home country to get the stamping. That's the reason we are advising probably consular processing is a better option. Now, is there a likely scenario that even though we requested the consular processing, they might still say that, no, you violated the status, we are not going to give you H-1B. There is a very slight chance for that, but we have to say, Mahesh, to you that, yeah, there is a slight chance for it, that they can still do that, but we have not seen that before.
Pranava has a good question, kind of you touched on it a little bit. So what exactly is the benefit of converting to consular processing over getting the change of status denied?
If when the STEM extension is being asked in the RFE that you're not maintaining the status, now you have two options there. One, you can prove that, look, the Department of Homeland Security, the regulations, the law are allowing me to work, the 983, the 765, everywhere. You did point it out, you're working at third party, say they're allowing you to work. You can challenge that. Now, when you do that, you can have two things done when you challenge it. One, they might approve your H-1B with the I-94, which we are good. You don't have to, everything is resolved. All those questions have been answered. The other thing they could do is that they can deny your change of status and approve the H-1B without the I-94. But when they do that, they are going to tell you that you have not been maintaining the legal status. You now are unlawfully present in this country, and the unlawful status will count from the time that you violated the status or August 9th of 2018, whichever is the latest. So when the USCIS determines that you are out of status, now you're taking that approval to the Department of State and the consulate. You're presenting to the Department of State, look, the USCIS told me that I violated the status. Here I come to you to get the visa. You might not have a good chance there as compared to if you requested for the consular processing, then the USCIS does not rule on your legal status. You have a better chance of getting the approval in the consulate. And as Emily was pointing out before, the USCIS seems to be at this point of time, now things might change, but it seems to be at this point of time, is predetermined to rule these people out of status if they have issued an RFE.
Yeah, and I think another important point to keep an eye on is the NTA memo.
Oh yeah.
So this memo, we've talked about it before here. Basically it says that if you receive a change of status denial, and at the time of the denial it's determined that you are unlawfully present, USCIS will issue a notice to appear in removal proceedings. Now again, this memo is on hold right now, But that doesn't mean it's going to be on hold forever. So by the time these decisions from USCIS on the H-1Bs are coming in, that memo could be in place. So not only are you risking a determination that you violated your status, which means that there's going to be unlawful presence from August 9th, you're also risking ending up in deportation proceedings on top of it all, when you could have avoided it all by simply requesting consular processing.
Chandu has a very interesting question, maybe a lot of people. What is a consular processing?
Yeah, that is a good question. So consular processing means that I'm filing my H-1B petition and I'm requesting that USCIS notify the consulate that my petition has been approved so that I can go and get my visa stamped from the consulate and come back into the country. So that's what consular processing is compared to a change of status where you're requesting USCIS to approve your petition and also change your status automatically from F1 to H-1B without requiring you to leave the country. So certainly for a lot of people, change of status is much more convenient, but due to the high risk of getting that denied and the big consequences of that denial, given the NTA memo, given the unlawful presence memo, we think that the safer option is going to request consular processing instead.
Rajiv, you asked this question that you have your H-1B selected in the lottery, you're working at the third party site, and yes, as you pointed out, there are a lot of people like that, and you have not received an RFE at this point of time. What should you do? Well, there's nothing much you can do at this point of time because the RFE is not issued, you cannot convert into consular processing. You may, one thing that I want you to do is convert into premium processing when in September they would allow you in premium processing. The reason why I would like you to convert into premium processing is that we have noticed that in 2017, some of the H-1Bs took a long time to get adjudicated. When the RFE is issued, they took a long time to after the RFE has been responded. And if it crosses February 5th of 2019, and if they at that point of time determine that you violated the status, you might be in big trouble. At this point of time, Rajiv, for those people whose H-1B has been selected and no RFE, please convert your H-1Bs into premium processing so that you get the result before February 5th, because you don't want to kick in the 180-day undocumented present rule. Now, if you get that 180-day unlawfully present in this country, though, then you have a 3-year bar in entering back into the United States. And that is where you need to avoid.
So we've talked about this unlawful presence memo and kind of how the third-party placement STEM OPT risk becomes greater because of the unlawful presence memo. And there's a section of that memo talking about reinstatement. If I just apply for reinstatement, then there's no unlawful presence accruing. Can you tell us what exactly reinstatement is, and will that help people that are in this situation?
In the STEM extension thing, there is no reinstatement, Emily. I don't know where they got this statement as if that the reinstatement is applicable to everybody. Reinstatement is applicable when you are going to school due to some extraordinary circumstances. You have to drop the school, and within that, after if you skip one semester and you're joining back, you get kicked out. When you stop going to school or when your grades drop, they will kick you out of the civic system. And then to get that civic system back again, to get you back into the legal system, you need to file a reinstatement with the USCIS. And once they adjudicate that, you will be back into position. While the reinstatement process is going on, the 180 days will be told. When I say told, I mean so that will be stopped. In other words, it will not be counted once you file the reinstatement. But the reinstatement is not applicable for the STEM extension. You cannot have the reinstatement in STEM extension. Not that I possibly think that there can be anything that reinstatement is available for the STEM extension people. It is available for those people. For example, you are going to school, you got a cancer, and then you have to have a treatment, and you have dropped a semester and you want to get a reinstatement. That's when the reinstatement is applicable.
Sachin has a question. We're talking about sending people to the consulate through consular processing. Isn't there a chance that they could get a 221G?
Yes. We never recommend people going for the consular processing in general. That's
right
a general
now.
policy. I, particularly Rahul Reddy, never advocates people to go in consular processing. But we sometimes have to choose the lesser of the evils that are there. There is an option here where we see the tendency of the USCIS indicating that they probably will rule you to be out of status. And then you go to the consulate saying that, I got this H-1B approval, but I got the ruling from the USCIS saying that I unlawfully worked in the United States. Now you're going to the consulate, you have a greater chance of denial there. So in light of the circumstances where we have to choose one devil over the other, I am choosing this devil of the consular processing. There are some other times where we choose consular processing, particularly when the person's status is in question. We have done many different times, and this is where we feel that it's not a good option, but the other option that you have is more worse option.
Yeah, Devanshu also has a question. So his H-1B is filed and pending. If he is found to have violated his status, now or in the future, are they going to count that from before August 9th?
No. Now, the August 9th memo is very clear that if they find you the status violation, it's the day you started the day you violated the status, or August 9th, whichever is later. Now, previous to August 9th, the ruling was that the day the USCIS denies your status because you violated, that's when the unlawful status counts, unlawful presence count. But the August 9th memo overruled that and said that it goes back to the day of violation or August 9th. It doesn't go back before, whichever is later will work.
So Pia has a question that has come up a couple of times, so I just want to reiterate. If you're on the STEM extension, working at a third-party site, you've got the H-1B filed and pending, or you receive a request for evidence, but it's on specialty occupation. It's not related to maintenance of status. Should you respond to that RFE? Yes, you should respond to the RFE. Whether you keep working at the third-party site or not is going to be an individual judgment call. We would suggest likely that it would be better to not be working at a third-party site going forward now that we're on notice from USCIS that they're not allowing that. But yes, you can respond to that type of request for evidence.
Yashwant has, I don't know, it's a question or a suggestion he is saying is that, well, the USCIS has updated the website, but they haven't denied the 765 application. What's your take on it?
Yeah, that's a very good question. It seems like maybe not everyone is on board with this website change yet. Maybe the officers haven't all been trained. Maybe only the H-1B officers have received training on this issue so far. We really have no way of knowing, but it is very inconsistent. I mean, even with our petitions, we have people who, and with people commenting here, we have people who are working at a third-party site on the STEM extension, and they have not received an RFE related to third-party site, yet others do. Why are some getting it and some aren't? Just a variation in officers. It's being very inconsistently applied right now.
Satish has this question that you're advising people to do the premium processing, and then you're telling that there is no evil in filing the premium processing. In fact, the ruling should be much before February 5th that the premium processing has to be there so that they can take preventive actions after being advised by their clients. When the RFE comes in, the premium processing is still applicable? I mean, do they still adjudicate the H-1B PT after the RFE response is done? Do they still respond within 15 or 20 days, or is it going to be 6 or 8 months?
Right, that's a good question. So yes, once you've upgraded to premium processing, USCIS is required to issue an approval or a denial or send a request for evidence within 15 days. If you get a request for evidence, once you respond back to it, the 15-day clock starts over. So even though they're adding an extra 15 days to the processing time, it is still way faster than responding to an RFE in regular processing, which is going to take at least 60 days to get the response.
We're trying to look into questions that were not been addressed in the video before. We're getting a lot of questions live, but we're trying to address those things which are not. One question is, I'm graduating in May of 2019. Can I apply in April of 2019? Yes, you can. I mean, you can avoid the complete thing. If you do so, that you must have completed all the coursework by April 1st. You must get a letter on the letterhead of the university that you completed the entire coursework, in which case you will be considered to be under the master's quota. But if you're filing under the bachelor's quota, you don't have to even get a letter of completion from the university. You can still file under the bachelor's quota. I didn't switch to consular processing. I am on CPT. My lawyer is suggesting to leave in October 1st. If I don't receive any update, is that a good suggestion? The person is on the CPT. Well, CPTs are a different issue. Definitely, you might want to consult your lawyer to actively. We're going to next Thursday. We're going to present exclusively on CPTs, day one CPTs. But for now, we're going to restrict ourselves to only STEM extension queries simply.
All right. Here's a question. So we're recommending people do the consular processing, exit the country. When they exit the country, is that going to cancel the unlawful presence completely that was accrued? How does that work?
Well, good, very good. The unlawful presence will not cancel. Well, what happens once you exit is that after you exit, your unlawful presence will stop. I mean, you're not in this country at all, so you could not be unlawfully present in this country. And the reason why we're emphasizing very much right now, now previously in the 2017-2016, we did get the RFEs particularly on the curricular practical training, CPTs. In those scenarios, it was quite different. In light of the August 9th memo, we don't want to touch the 180 days. I want you to point out, you guys to go back and watch the video that we presented on August 9th about the August 9th memo, because that has some very good tips for you to observe. So the reason why we want you to exit before February 4th is we don't want you to accumulate the 180 days. If you do get touched the 180 days, then you are in a big other soup.
On that note, if I'm working at a third-party site right now on my STEM OPT, and next month I switch and work in-house, does that make my unlawful presence go away? Does that make my violation go away now that I'm in compliance?
No, it doesn't go away, though you might want to consider to consult a lawyer. Even though it might not go away, you may stop accruing further into the 180 days. Here is how it is. Let's say, for example, on August 1st, you're working at third-party site, and the USCIS later determines that all the people working at third-party site are not properly working. So from August 1st onwards, from the time that you worked on, the unlawful stay will keep on counting, even though on August 20th you moved to a direct employment. That unlawful stay might keep counting all the way. So to hold that, you may want to travel to Mexico, but I would advise you to consult with your lawyer, because there are some risks associated with it if you can travel to Mexico and come back. Because if you travel to outside the country and come back into the country, you might be stopping the 180 days accumulation of the unlawful presence. That's the reason travel might take away the 180 days. But by staying in United States, you might be accumulating the 180 days, and it might affect you at a later date when you're filing a H-1B, even though now you are working at the direct employer site, because previously you worked at third-party site. That might affect you on your H-1B. It might affect you on the green card. It might affect you when you go to a home country and get the stamping. It might affect you in all different circumstances.
All right, I think we have pretty much answered all of the questions directly on the STEM OPT and third-party placement. So I think we'll wrap it up for now. Thank you for joining us today.
Yeah, stay tuned for the CPT things that we're going to present pretty soon, day one CPT. Please, if you want to make any appointments with me, Emily, or any of our colleagues, you can always log into rnlawgroup.com and you can make an appointment with us. And stay tuned to Radio Newman PC. Thank you for patronizing with Radio Newman PC. Thank you, guys.